classic example, and you guys may have heard this fact pattern before for good reason, but a tailor comes to the United States to take measurements for and take orders for people that have placed orders for clothing from a company that is placed abroad, whose principal business is abroad. And that tailor is paid by the company abroad, and the solicitation of business in the United States is done by the company that is located abroad, but the person is in the United States taking orders and receives pay for incidental expenses, for the travel, for lodging, etc. So that is your classic example. You may have recognized that example from the case matter of HERA, and we will discuss that. But that's one example, and the question is, is that permissible?
So let's say, for example, you happen to live in Philadelphia and you got some tickets to go to the Super Bowl this weekend, go Birds, and you call your friend from Canada who doesn't like football, and they come down to house sit for you and pet sit for you. And while they're down here, you feel bad because they've spent all this time and you're celebrating a huge victory in Arizona. You decide to give them a little bit of money for their trouble. So this house sitting, pet sitting scenario is something that's actually been addressed by CBP, and we have some rules around it. And it's one of those incidental type of work things that has become more and more commonplace, but is becoming problematic.
So matter of HERA, you guys may have seen in the Foreign Affairs Manual, USCIS cites matter of HERA. It is the classic case that deals with what is a permissible B1 activity in the United States. And the board in that case decided that it was permissible activity for the tailor to be in the United States taking orders where the principal place of business was abroad, where the source of remuneration was abroad, and where the impacts to the local labor market was minimal, if any, if at all. So, the labor that was taking place in order to fulfill these orders was taking place abroad in Hong Kong. And so this was permissible. And I think that those factors, especially the principal place of business being abroad, the source of remuneration, and the place where the individual was paid is abroad, and the minimal impact to the local labor market, are three key factors that the government uses now in determining whether or not an activity is permissible. And you'll see that across various sources. We have liaison minutes. We'll talk about, our national liaison minutes. South Florida has recently published liaison minutes, which are with its CBP committee, which I'm on here locally, which gave some real good clarification on the question of, the question that we're talking about today. But same with, there's a memo called the Williams memo which is 20 plus years old, which delineates some factors, and it all kind of is based on matter of HERA. And so again, I'll put the matter of HERA site in the chat, but that's the general legal framework that we're working with here when we're determining whether an activity is permissible.
One thing I really would point out is that when dealing with CBP, and we've been told this like specifically in the liaison minutes, they don't dig on the Foreign Affairs Manual. Like the Foreign Affairs Manual has an amazing section on what you can and can't do as a visitor and when they will issue a visa for B1 and B2 activities. CBP does not feel, I would say, bound by that in any sort of way, shape, or form, and they kind of take on their own interpretation. And that's why, in particular, and Helen, to your question, we'll definitely be posting the resources to the liaison minutes that we're referring to. But that's where these liaison minutes and meetings come into play, because that's like the direct interpretation that we are getting from the border. I will say I often frame things out from the FAM when I'm looking at an issue, and I will raise it, but don't say to CBP, you have to do this because it is permissible under the Foreign Affairs Manual. Now, with respect to this issue of pet sitting, this has been deemed to be work. You are getting compensation for labor that is occurring within the United States, and it is affecting the labor market itself. And if you do look at the Williams memo from 2000, they give a really nice like 3-factor test when determining whether or not the activity is permissible. And one of the questions is, will the individual be compensated from a US source? So, I mean, I guess in some way with your pet sitter, you have to consider the fact that the money is coming from a US source. And then will the individual, even if uncompensated, perform services for which a US worker would have had to have been hired, or are the services inherently part of the US labor market? And I think that one in particular is where you're going to have a problem with CBP in the pet sitting scenario or the house sitting scenario. That is a service that US workers provide. It is very local. So unlike our Taylor situation where the work is being performed outside of the United States, here we have the work being performed inside the United States, and the compensation is also being provided in the US.